We simply cannot allow people to pour into the United States undetected, undocumented, unchecked.
And complete the dang fence.
This bill that we will sign today is not a revolutionary bill.
Cast down your bucket where you are.
We come from France.
And I am, adamantly against illegal immigrants.
They're coming in by the thousands, just unbelievable.
A wall is an immorality.
Who are you rooting for?
Those masters of the universe are at it again.
You maniac! You blew it up!
Welcome to Parsing Immigration Policy, the podcast of the Center for Immigration Studies. My name is Mark Krikorian, Executive Director of the Center. And today we're going to talk about something that's been in the news a lot. It's a deportation case. It just relates to one person, but it's very important. This is the case related to Mahmoud Khalil, the Hamas supporter who apparently is or was a student at Columbia University, was involved in the pro-Hamas protests there, and the administration has started deportation proceedings against him. And so there's a whole bunch of different issues here. Foreign policy issues, free speech, what have you. And so I thought it would really be worth having on to talk about what are the various issues involved here. Two of our legal eagles who have written extensively about this issue, George Fishman and Andrew Arthur, have both written on this a lot. We'll have links to their various posts in the show notes, but I thought it would be good to have the two of them sort of talk through some of these issues. And, there's a certain entertainment value because George and Art have a kind of Abbott and Costello or Laurel and Hardy kind of thing going on too. So hopefully it'll be more entertaining than your average legal podcast will be. George and Art, thanks for coming in. George, if you could maybe just give us the very brief kind of what's going on, what's this about, who is this guy?
Well, sure. He was I believe, a graduate student at Columbia University and was involved in the pro-Hamas, anti-Israel, divest from Israel organizations, participated in the pro-Hamas protests after the Hamas's mass slaughter of Israeli citizens, civilians in October 2023. Was self-appointed himself as the negotiator between the protesters/rioters at Columbia University and the administration of Columbia University, during the takeover and vandalism of university buildings. Allegedly, Jewish students were prohibited from entering certain classroom buildings by the protesters, things, handing out Hamas leaflets, basically implying that all the Jews in Israel should be murdered, things of that nature. And I called years ago for people such as him, assuming they've done things such as he's been said to have done, to be deported. They're aliens. They do not have they have certain First Amendment rights, not the same First Amendment rights as U.S. citizens, and they should be removed. Of course, the Biden administration completely ignored my advice to seek their removal. But the Trump administration is seeking not only his removal, but as Art has written about, the removal of other aliens who are supporters of terrorism.
So in a sense, this is a test case for a potentially broader effort.
Yeah. The interesting thing is the theory, and Art can talk more about this, the theory they're apparently using to seek his deportation is the ground of deportation based on adverse foreign policy consequences for the United States of his continued presence.
Mm-hmm.
There is, in addition, a ground of deportability for aliens who endorse or espouse terrorist activity. Art and I know about that because we were staff members for House Judiciary Committee Chairman F. James Sensenbrenner when he got that provision of law enacted in 2005 as part of his Real ID Act. And that provision of law, providing for the deportation of aliens who endorse or espouse terrorist activity, has never actually been used since then. We need a test case because,
right.
Some people are going to argue it's unconstitutional. We need a test case on that. We need a test case on the foreign policy ground, because to my knowledge, there's only been one federal court decision on the constitutionality of the foreign policy ground of deportation.
Which specifically just explain what that is. And what does that mean?
Yeah, the district court said, it's...
No, not the court, but what does the provision in the statute say?
And
I don't need the wording of it, but what's the point of it?
If it's determined that the alien's presence in the U.S. would have potentially adverse foreign policy consequences for the United States, that's a ground of deportation.
According to the Secretary of State, right?
Yeah. And there's a higher standard if the basis of that deportation would be the beliefs or statements of the alien, which would be lawful if made in the United States.
Right.
But then the Secretary of State needs to really have compelling reasons for doing it in his mind. But yeah, that is the provision.
So, Art, the way this has been talked about in the media is that it's a free speech issue and that, the First Amendment says you can say whatever you want. And as George referred to, there's a provision in the law passed after the fall of the end of communism that, if I remember correctly, Barney Frank, when he was in Congress, championed that says you can't deny a visa to somebody, to a foreigner, because of their belief statements or associations, if those belief statements and associations would be lawful by a U.S. citizen. And frankly, if you're a U.S. citizen, you can espouse terrorism. I mean, you can't belong to a group or give money to them without consequences, but you can just stand up and say, hi, I'm for Hamas and I want to kill all the Jews. That's not going to get you arrested. So in a sense, there's two provisions in the law here that are kind of, it seems, at odds with each other. So I don't know, is this really a free speech issue or is it not?
Yeah, and it goes right to the heart of this ground of removability, as George alluded to. Section 237A4CI of the Immigration and Nationality Act allows for the deportation of any alien, including a green card holder, if the Secretary of State has reasonable ground to believe that that individual's presence or activities in the United States would have potentially adverse, serious foreign policy consequences. And what you're alluding to, Mark, is the exception to that rule. That rule says that an individual cannot be subject to deportation under this ground if the alien's beliefs, statements, activities, or associations in the United States would be legal. And, George very briefly alluded to the exception to that exception. And that allows the Secretary of State to nonetheless declare that individual removable if the individual's presence in the United States would compromise a compelling national security foreign policy interest. So the argument that Mr. Khalil's supporters are making is that everything that he's done has been legal, that it is protected speech in this country, that he's never crossed the line. And we still haven't seen publicly the letter that the Secretary of State has issued with respect to this ground of deportability. But we have seen reference to it in various articles, reference to some of the provisions. One of the allegations purportedly is that Mr. Khalil led activities aligned to Hamas, a designated foreign terrorist organization. Mm-hmm. And needless to say, if an individual in the United States is leading activities aligned to a foreign terrorist organization, that alien's presence in the United States would have serious adverse foreign policy implications because it would indicate that the United States isn't serious about designating groups as foreign terrorists or supporting its allies. Another allegation, I believe this was in the New York Times, suggested that he had engaged in anti-Semitic activities. Again, I haven't seen the letter. I don't know whether it actually contains specific actions that they allege that he has engaged in. But that's apparently the basis of the charges that Marco Rubio, the Secretary of State, has lodged against him. He appeared on Friday at a hearing, and apparently the government is now making additional allegations against him. Mm-hmm. And one is that when he applied for his green card, he failed to disclose the fact that he had worked for the United Nations Work Relief Agency for Palestinian Refugees in the Middle East. And this is a group that the State of Israel has contended that members of that group actually participated in the October 7th attacks. Again, they're not charging him with a separate ground of deportability, but they're asserting that that is an additional basis under which he should be detained, because right now he's sitting in Jena, Louisiana at a ICE facility down there. He was originally taken into custody and taken to Elizabeth, New Jersey, but apparently there was a bed bug outbreak there and they had to move him. And so they sent him to Louisiana. But yeah, I mean, once we actually, can see that letter, the American people have a lot better idea what exactly, all the facts of this are. I don't believe that ICE has released that letter. The State Department hasn't. So really everything that we're hearing is more or less filtered through his attorneys, and they are legion. He has a number of attorneys, including an attorney that I knew very well in San Francisco, who is probably one of the best immigration lawyers in the country. So it'll be interesting, but I think that in the course of the hearing on this case, there's going to be a lot of back and forth. Again, he's going to bring in supporters who will say that he attempted to be a mediator. One person referred to him, I think, as a gentle diplomat in discussions between the Columbia University Apartheid Divest, which is the organization that's been running the protests up at Columbia University, and the administration.
Pretty soon he's going to be an honor student who, calls his mother every Sunday and rescues cats that are stuck in trees. Anyway, I mean, there's a certain fight going on in the court of public opinion as well as in the, wherever this is, New Jersey District Court or wherever this is being heard.
Yeah, no, so the original judge changed venue from New York to New Jersey, but again, he's being held in Louisiana, and it's sort of interesting that they haven't filed a habeas action in Louisiana to get him out of custody, but the judge in New Jersey has actually said that DHS can't deport him until eventually they reach a determination at the end of this case.
And actually that underlines something that this administration is doing. They do seem to be, and not just here, but in other cases, trying to create, lawsuits. In other words, they're looking for opportunities for litigation to get some resolution on these cases rather than the kind of hyperbolic talk about constitutional crisis and all the rest of it. What they're doing is basically creating lawsuits so that they can be litigated and there can be some determination on this. George, I wanted to ask you something sort of to continue on this issue, and this may or may not apply specifically in this guy's case because they're making the argument of the foreign policy argument that trumps the other parts. But it seems that the provision in the law, the post-Cold War provision that you can't deny somebody a visa because of his belief statements or associations if they would be legal in the United States for a U.S. citizen, is in conflict with the provision that says you're excludable or deportable if you endorse or espouse terrorism. And so, it seems to me that's a contradiction in the law that has never been kind of pushed to its logical conclusion, or am I missing something?
They are certainly inconsistent, not strictly in conflict, because one involves one ground of deportability,
right?
One involves another ground of deportability. Okay. So you potentially couldn't be deported on the foreign policy ground for endorsing or espousing terrorism, but you could be deported under the terrorism ground of deportability for endorsing.
No, but my point is the terrorism ground itself, in other words, unless you're a member of a terrorist group or supporting, that's a whole separate thing. But if you're endorsing or espousing terrorism or terrorist groups, that's a legal thing for an American to do. And so isn't that in conflict with the provision that says as long as you're not doing anything that an American would be arrested for, you can do it as a foreigner?
Yeah.
You see what I mean?
Yeah, they're in conflict in the sense that the Congress who passed one would most definitely not have passed the other.
Right, yeah, okay.
One was passed in 1990, one was passed or enacted in 2005, and yes, they were some cognitive dissonance there.
Right. So, but my point is, in a sense, that's one of the reasons we have litigation, right, to sort of resolve some of these issues. One thing that I wanted to ask about, maybe whoever wants to answer this, but start with you, George, is that, first of all, is there a difference between what a non-immigrant foreigner who's here, in other words, a foreign student, a tourist, what have you, what's called a non-immigrant visa, the rights he has versus a lawful permanent resident, somebody with a green card who is, at least, the way it's publicly understood, is kind of more, he's sort of an associate member of the American people. He's not an American citizen. He's still an alien, but he can become a citizen after jumping through a few very minimal, quite frankly, hoops. Whereas somebody here on a student visa it's by definition temporary, even if they're here for a number of years. So what's the issue there? Because this guy has talked about, Khalil has said, he's kind of muddied the issue as to whether he has a foreign student visa, because at one point he said his foreign student visa was withdrawn or something, but he also has been described as a lawful permanent resident, which are two obviously totally different things. Is there different levels of how much you can support Hamas, basically, depending on whether you're a green card holder as opposed to a temporary visitor?
Mark, that is an excellent question, and you appear to be channeling the back and forth in the mind of Supreme Court Justice Brett Kavanaugh. Before he was a Supreme Court Justice, when he was a Circuit Court Justice, he wrote an opinion affirming a federal statute saying that aliens who are not permanent residents are forbidden from giving campaign contributions in political campaigns.
So this is a non-immigration issue, but it's getting to this difference between green cards and non.
Yeah, it's not an immigration issue, but it's a First Amendment issue, because ability to contribute money to a cause you believe in, a politician you believe in, is a First Amendment issue. And his ruling, which the Supreme Court later upheld before he was on the Supreme Court, said that regarding non-permanent residents, it's perfectly constitutional to prohibit them from contributing.
Non-permanent, so foreign students, campaigns, tourists, what have you. Yeah,
exactly. But he said in his opinion, however, if this guy had been a permanent resident, well, I don't know, maybe the answer might be different. So there's not
dicta is what they call it, right? In other words, it's just sort of thinking out loud rather than a ruling.
Exactly.
Okay.
So there's not a clear answer, but that's one of the issues the Supreme Court's going to have to determine. Is there in fact, and to what level is there a difference between someone on a student visa and someone on a green card? Khalil apparently was on a student visa, and then on a quite expedited basis, apparently, was given a green card based on marriage to a U.S. citizen by the Biden administration. Okay. Very expedited. What was involved in that? Maybe Art could comment more than I, but yeah, so he's been in both, apparently in both situations.
So that would be worth actually, worth USCIS investigating, presumably, is what was involved there. So Art, if you had any thoughts on that, but also not just the green card versus a non-immigrant temporary visitor, sort of what their rights are, as it were, in this context, but also if he just got a green card relatively recently, because apparently that's what it was. I mean, he was a foreign student until not that long ago. It presumably for the first 2 years of a foreigner marrying a U.S. citizen and getting a green card, your green card is conditional for those first 2 years. Now, the conditional part, as I understand it, is just to make sure it's not fraudulent. In other words, that, you know what toothpaste brand your spouse uses, that kind of stuff. It's like the movie Green Card with Gerard Depardieu, and Andy McDowell. In other words, to make sure it's legit. But the point is, it is still conditional. Does that conditionality have any implications in this area, or is basically an alien is an alien is an alien, as you might say? Art?
Yeah, no, and, it goes to some points that George had just alluded to. When we talk about foreign nationals in the United States, when we talk about aliens, we refer to what's called a spectrum of rights. And that spectrum of rights runs from the ports of entry or, individuals who have just crossed the border, who the Supreme Court has held have only the due process rights that Congress has, given them by statute. When an alien, is admitted to the United States and begins to live in our community, that individual gets more rights. Non-immigrants, have more rights than somebody at the ports of entry. And then green card holders, conditional green card holders, have more rights than non-immigrants. And, LPRs, lawful permanent residents, are pretty close to the top. And then once they naturalize, they have all of the rights that other United States citizens do. And these are going to be the issues that are going to be, that are going to be addressed in this case, or that I hope are going to be addressed in this case, because there are plainly limits that, as George had, very eloquently said, that we can place on foreign nationals in this country that would be unacceptable if we were to impose them on United States citizens.
Mm-hmm.
And it's, as we're having this conversation, I think about it. One of the things that we saw over the last 4 years under the Biden-Harris administration was that there was an attempt to elide or erase the distinctions between citizens and aliens.
Right.
And it's, possible that one of the things that the Trump administration is attempting to do is to, sketch out more of a boundary between individuals who are aliens, even lawful permanent residents, and, the rights and privileges of citizenship. We've certainly seen a number of cities and towns across the United States attempted to allow aliens to vote, which we traditionally think are one of those things that is reserved for citizens. And I think that, this is almost, we talk about a pendular swing in immigration policy. I think that's part of the pendular swing we're seeing.
So in a sense, you're talking about the spectrum of rights based on the spectrum of statuses, I guess. What the administration may be doing and what this case will clearly, in one way or another, resolve is a kind of making the blurry spectrum a little clearer. In other words, if you look at a spectrum of light, where's the green end and where's the blue start kind of thing? Clarify what this spectrum is. It kind of reminds me, it's not exactly germane, but I just loved this quick skit on Monty Python years ago. Monty Python's Flying Circus, the TV show, where they said, how can Britain raise more money? And so they asked a bunch of guys, actors dressed up in bowler hats like they were bankers in the city of London. And they said, well, what we need to do is, tax all foreigners in Britain. And then the next guy said, no, I think we need to tax all Britons abroad. And then the third guy said, no, we need to tax all foreigners abroad. And so in a sense, it's sort of a similar application of the First Amendment. It applies to all Americans abroad, and it applies to all foreigners in the United States. And does the First Amendment apply to all foreigners abroad? So anyway, I just thought that was a hilarious little bit. Like I said, in a sense, the previous administration, and it wasn't just them, but was trying to blur and successfully blurring the line, not just between citizens and non-citizens, but even between legal and illegal aliens. And so in a sense, what we're seeing in this case, and I guess in others, is an attempt to kind of set some clearer lines where it's now blurry on what a non-citizen can do and what he can't do. Any thoughts on that, Art?
Yeah, absolutely. We see that in the birthright citizenship case.
Right, yeah.
And one of the points that I've made, is that the law doesn't like ambiguity.
Mm-hmm.
I can tell you exactly, how much air you have to have in your tires to drive a tractor trailer from Georgia into South Carolina. But there isn't any dispositive statement of which children of foreign nationals born in the United States are citizens. When you talk about this spectrum of rights, it's one of those things that you see alluded to in law review articles, that survey the various laws, but there hasn't really been a strong statement from the Supreme Court about any of it.
And so in a sense, the reason you have this ambiguity is because no one's ever used these powers, or very, very, very seldom ever used these authorities before. And in a sense, it seems to me it kind of lets Congress off the hook for those powers not to be used, because Congress, at least the ones who supported these measures, get to say, I'm all for, deporting people who espouse terrorism, and then it never gets used. And so it's kind of almost like these are measures that are what Senator Moynihan years ago called boob bait for Bubba. It looks strict, but then it's never used, so it's meaningless. And so, whatever you think about the Trump administration, and obviously, we're obviously generally sympathetic here, but even if you're not, this is a useful service, in my opinion, a useful action, because it is kind of forcing the courts to actually deal with these issues and say something about them. George?
Mark, I agree wholeheartedly. I can assure you that when I was working in Art 2 for Chairman Sensenbrenner, and this got enacted, The goal was to have this utilized, and it was very disappointing to me that no administration, Republican or Democrat, has in the past 20 years ever used the endorse or espouse ground of deportation. If I could just quote briefly Michael Kagan, a professor of law at University of Nevada Law School, the Supreme Court through the years has sent ambivalent and conflicting signals about immigrant free speech rights. It has never quite said that immigrants do not have all freedom of speech. It has, however, never unequivocally said that they do. Additionally, it has issued recent decisions that affirm government power to limit immigrant speech, either in the election campaign context or in terms of selective enforcement of immigration laws. There is ambiguity, and you're absolutely right, and Art's absolutely right. We need to get this ambiguity out of the way.
Right.
We need to know what the law is.
Not to put you on the spot, but you were Deputy General Counsel of DHS for part of Trump 1.0. Was there any discussion of addressing these issues, of sort of bringing them to a head at that time? Or is this something that, had they considered and dismissed? Did they never think of it? They were overwhelmed with other stuff. What can you tell us, if anything, about that?
All I can say is I'm not aware of there ever being in any administration any discussion of using this. My advice is to any administration, don't be defensive about trying to remove aliens on grounds of their support, of their belief in murder, in mass murder, in genocide.
Right.
In 2004, the Congress enacted legislation saying any alien who incites genocide is deportable. My knowledge, that's never been used.
You do have to incite it, though, in this case, right?
Yeah.
In other words, not just espouse it.
Well, yeah, but if someone's with a bullhorn at Columbia University saying, we love Hamas trying to kill all the Jews in Israel.
Right.
In my mind, that's inciting genocide. Maybe it is, maybe it isn't, but someone should bring that case.
Right. Interesting. So, Art, I guess both of you, but Art, any thoughts on where this case is going next? Is this the kind of thing that's going to last into the second term of the J.D. Vance administration 12 years from now? Or is this something likely that, might get resolved with sort of expeditiously? What are your thoughts on that, Art?
So, here's how this is going to go. This case is going to go in front of an immigration judge. The immigration judge is going to look at the only precedent on this, which is a case called Matter of Ruiz-Massieu from 1999, conclude that he or she can't look behind the Secretary of State's determination and probably order him removed.
Okay.
He'll appeal it to the Board of Immigration Appeals. The board is probably going to sustain the IJ order. The real action is going to happen in federal district court.
Just to be clear for people, after it goes from the immigration judge to the Board of Immigration Appeals, which is basically above the immigration judge, it then can go to district court. Is that correct? The regular federal court?
Well, it normally goes to the circuit court,
okay.
But there's going to be arguments that are made in the course of the habeas action that he currently has pending in New Jersey, where he says that this entire ground of removability is unconstitutional. Now, more likely than not, that district court is going to wait until the Board of Immigration Appeals rules on this before it actually talks about the constitutionality, because there's a principle that he has to exhaust all of his administrative remedies before he goes to federal court.
Right.
At that point, it will probably go to the Third Circuit, regardless of whether he wins or loses, and it's going to end up in the Supreme Court. But let me just note something interesting. That's more, what I've just laid out is more or less how it went in the case of Salvador Ruiz-Massieu, who is the Ruiz-Massieu in Matter of Ruiz-Massieu, is the former Deputy Attorney General of Mexico, who attempted to depart the United States, I think to Spain, with $26,000 in undeclared cash on him. But the judge who overruled the district court order, the judge in the Third Circuit who wrote the decision, was Judge Samuel Alito, who is on the Supreme Court today.
What did Alito rule? In other words, did he rule in favor of his removal or against it? What did he say?
So the district court judge in that case had attempted to enjoin removal on this ground, said that it was unconstitutional. Alito was the judge writing for a 3-judge panel who said, no, you have to exhaust all of your administrative remedies before you can come into an Article 3 court to actually argue these things. And again, the BIA didn't issue its decision until 1999. And Mr. Ruiz-Massieu unfortunately died a few months after before it could ever go up on appeal again.
I see.
But yeah, I mean, Samuel Alito is probably one of the few judges that has ever handled this ground of removal. And so he's a guy who understands it. And, it'll be interesting when it gets to the Supreme Court. And, fortunately, we've got Amy Coney Barrett, who is a former law school professor. And this whole idea of the spectrum of rights is one of those things that really only ever gets discussed at the law school level. So
interesting.
We got some good justices who definitely know the issues. And I think they're going to hammer out some pretty solid precedent one way or the other.
Any thoughts, George? You agree with that? Disagree? Anything else?
I agree with Art. And I think not only should it be determined by the Supreme Court, we really need Supreme Court precedent guidance. So administrations, prosecutors, this one or any other one, are not leery of using these powerful tools to rid we're talking about guests in this country, either invited guests or uninvited guests.
Mm-hmm.
And as Senator Tom Cotton has said, there are all sorts of heinous things that U.S. citizens can say. But the thought that we have to tolerate guests in the United States proclaiming and advocating for these things, that's a whole nother story.
Right. And just to sort of wrap up on this is not really an instance of necessarily of kind of activist judges overstepping their bounds, as the administration has claimed in other areas, and I think is frankly claimed with some justice. This is something that really does need to be litigated if Congress isn't going to offer clarity. And Congress has enacted various statutes, and kind of the whole reason we have a judiciary is to interpret the statutes. And so this is, in other words, this is a kind of legitimate area of litigation rather than lawfare.
Yeah, until an administration attempts to deport someone on this basis, and that person challenges the deportation, there's nothing the courts can do. There has to be a case or controversy.
Right.
And so, my congratulations to the Trump administration for, in this case, creating the case of controversy so we can get the Supreme Court to make the ruling. And, unfortunately, there have been instances in the past few years where the Supreme Court has decided to squirrel its way out of having to decide these tough issues. When the Supreme Court determined that the Trump administration's attempt to terminate the DACA program could not go forward, Justice Roberts, in his majority decision, essentially said, we're not deciding whether DACA was illegal or illegal. We don't need to decide that to decide this case.
So they punted, basically.
They punted. We need, and, I think it might have been Justice Barrett who said, look, this is just punting the case. We need a decision here.
And so in this case, this is kind of hard to punt. They're going to have to say something here, one way or the other.
Exactly.
Whereas like on the birthright citizenship case, I think Art has said this, or maybe others have, I think they're going to punt. So we're not going to get a real decision there. But in this case, it's kind of hard to punt. Either the guy gets deported or he doesn't, in some sense.
My only suggestion here is, an administration needs to pick the case with the best possible facts.
Right.
If you're going to try to get Supreme Court precedent that this is in fact a legitimate constitutional way to remove someone, find the worst poster child available, because unfortunately judges are people, and sometimes the facts of a case may, totally apart from the legal issues, may affect what the outcome is. And so,
there is a legal element to the old aphorism that, what is it? Hard cases make bad law. So in a sense, if you want clear law, choose good cases, in a sense.
Exactly.
Yeah.
And especially, this is, a military term, a target-rich environment. There are a lot of aliens in this country who hold and advocate reprehensible views, even if they're not members or contributors to designated terrorist organizations. Of course, many of them are. And so there are a lot of aliens,
a lot of low-hanging fruit
to
here.
choose from.
Exactly. Any last thoughts, Art?
To a couple of points that George made, a lot of people across the country outside of Morningside Heights or outside of the D.C. Beltway look at what's going on at Columbia University, an Ivy League school, and they're, somewhat shocked that, students, are protesting in favor of what was a reprehensible day in American history, the worst day for the Jewish people since the Holocaust. And I think that politically, this is one of those things that the Trump administration wants to have this case because it'll actually give the administration opportunity to litigate what's happened at Columbia University. Most of the things, the actions that have gone on there, if you try to figure out what's happened, you'll get responses that are all over the map about what occurred. But you need to have a case of controversy in order to discuss that. This is a case in controversy that the Trump administration can use to put the entire Columbia University apartheid divest movement and other college protests under the microscope so that they can be decided in the court of law, not in the court of public opinion. But it will still influence the court of public opinion.
I agree with Art. And, why did this happen at Columbia? 1/3 of all the students at Columbia University are foreign students. That's something I'm sure,
That's a topic for another show, but
yes.
It is an important policy issue. I mean, the whole foreign student, it's an unlimited, there's no numerical limits on foreign students. There's no percentage limit for any individual institution. It really is something that has, in a lot of other countries as well as here, has gotten out of control and needs to be addressed. But one thing at a time, at least for our podcast. So we'll wrap that up for this week. Thank you, Art. Thank you, George. And we'll have links to their various postings and op-eds on this issue of deportation of Mahmoud Khalil, but also, obviously, he's kind of the, poster child, if you will, for this issue of how and if and how we can remove from the United States aliens, non-American citizens who are espousing repugnant and appalling ideas and statements, and whether we're even allowed to do something like that. So thank you, George. Thank you, Art.
Thank you, Mark.
Thanks for having us.
You'll be following this issue, I'm sure, and we will probably have you back to talk about it in the future. There was one thing I wanted to bring up that's different from the subject that Art and George and I were discussing, and that is this issue of self-deportation. And specifically, this week, I was waiting on hold for a radio interview for a Houston radio station. And one of the ads that I've seen elsewhere came on where DHS Secretary Kristi Noem was basically saying to illegal immigrants, get while the getting is good. You need to pack up and leave on your own time. Otherwise, we're going to find you and remove you. And then, you won't be able to come back. And this reminded me of public service campaigns, advertising campaigns like this that other administrations had done. Basically, messaging campaigns, radio, TV, public statements, internet, that sort of thing. And in the Biden administration, they actually ran ads in Central America. Don't come to the United States. It's dangerous to travel here, etc. And infamously, Vice President Harris went down and said, do not come. And she said it twice. So apparently she was, trying to convey that she was serious. But the fact is that actions speak louder than words, and people who came anyway and turned themselves into the Border Patrol were just let go. Heck, the Border Patrol even had luggage tags for people who brought suitcases with them. And they would put the luggage tags on and take the luggage in a separate truck to the Border Patrol processing facility, and you kept your little stub so that you could claim your luggage. I mean, it was like a bus line or an airline or something. I mean, it was that ludicrous. And so when the actions of people who came showed that you could get away with it, it doesn't matter what ads they ran in Central America. Well, the Trump administration is basically trying to do the opposite. It's not just running ads saying, don't come. It's running ads in the U.S. to say, pack up and leave, like the one I heard on the Houston radio station. And the question is that going to do any good? Because the first point is that they're in English. And, will immigrants hear those if they don't know English? I mean, illegal aliens in particular, relatively recent arrivals, aren't likely to have a firm grasp of English. But at the Washington Examiner, Anna Giatorelli did a story basically saying, okay, well, are these ads and this messaging doing any good or not? Surprised no other reporters have bothered to look into this, but she's pretty good in her coverage of immigration. And she talked to people, and the answer is yes. There was an immigrant rights activist in New York she spoke to that said it is prompting some people to self-deport. And the point here is that even though the ads are in English, and not just ads, of course, it's postings on Twitter and speeches and all the rest of it. The whole messaging is in English because that's our language. But that it is a significant enough push that it gets covered in foreign language media, both abroad and here, Spanish language radio stations, Chinese language websites, directed toward newcomers, that kind of thing. So in a sense, the government doesn't even have to translate it because the foreign language media will do the translating for them and amplify and spread the message. But, and this is the important point that gets back to the failure of the Biden administration's messaging, is that the actions have to mesh and be consistent with the messaging campaign. The messaging is important because you want to amplify this idea that, in this case, go home, get out now so that you avoid law enforcement. But it's important that there be something to back it up, that people actually be detained, that they be removed, and they be removed in a high-profile way, which is one of the reasons the administration has highlighted people, being loaded onto planes or, returning in shackles to their home country or what have you. So when the facts on the ground match the messaging campaign, they reinforce each other. And it does work. Like I said, Anna spoke with several people, not just the one I mentioned in New York, but an immigration lawyer, who said that, in fact, and the quote from the lawyer was, the messaging, quote, created substantial anxiety among undocumented individuals, unquote. And that's the point. Nobody should be scared of their lives or anything like that. Nobody's coming to beat you up in your home, but anxiety is the right feeling if you're a lawbreaker. Anxiety that you will be detected and removed. And so the point of all of this is to get people to act on that anxiety and pack up and leave. And there's a certain amount of that happening. Again, these immigrant rights groups are acknowledging that it's happening. It's hard to measure. In fact, I would say at this point, it's impossible to measure, but it's a real thing. And it is both to the benefit of the American people, but also to the illegal immigrants, for that to be sustained and even ramped up, because it saves us the expense and time of detaining and removing people, but it also saves the illegal immigrants themselves the cost and even, let's face it, the humiliation of being arrested and processed and removed. If they go home on their own, they can, make their plans, pack up stuff, mail packages home, whatever they're going to do, and go back on their own terms and their own way. And everybody wins that way, except those who don't want American immigration laws and American borders to be enforced. But the fact is that something that benefits the American people does in fact benefit the illegal immigrants in a sense as well, is the kind of outcome that we should be aiming for. That's it for this week's episode of Parsing Immigration Policy. This is Mark Krikorian. Thank you for listening. Thanks to Brian Griffith, our producer, for making this thing work. And I hope you will tune in next week.